So this is the dreaded last panel of the day. Professor Lambert and I were talking about how we were going to split up moderating the panels, and he thought that he was being very clever taking the substantive panel and leaving me the also dreaded procedural panel. Little does he know that I love procedure. These are my people here, the proceduralists, which we know that it's all about the procedures you follow in making regulations that are the most important. So it's my pleasure to introduce the afternoon panel, and I have spoken in many of an afternoon panel. In fact, the students all know that I give the last speech the last day of orientation. They've had 3 days of don't ever get a DUI or you'll never be able to practice law. And then I come along, and so I am the comic relief portion, but I have to introduce my speakers, so there'll just be a little bit of humor in here. So the speakers are lined up, because I told them how to, in the order in which they're going to be speaking. So I am going to be introducing from your left, your right, your left, so this person here, Ken Davis, I'm going to be introducing first. Okay, so Ken is a senior attorney with the firm of Hunt, Andrews, and Kurth. Little story about Hunt, Andrews, and Kurth. There used to be Hunt and Williams and Andrews and Kurth, and they merged. And I said to him, your firm, Hunt and Williams, really didn't do very well because you only got one of the names and they got 2 of them. And then he showed me his business card. And Hunton is like the size of the letters on Trump Towers. And then Andrews and Kurth is kind of in very small letters. So I think that they won out. So Ken obtained his law degree in the Missouri Law School of the East. I think they call it Harvard. He's worked over the years both in his law firm in the private sector and in the public sector. He started off working on the Hill. He was a legislative aide. Then he was a speech writer, think West Wing, for members on the Hill. And then most recently, he was Deputy Attorney General for the state of Virginia. Now, I don't know if I think Virginia might have been in the news lately, but he is now next in line. So I asked everyone to tell me something a little bit interesting about themselves. And what I learned from Ken is that, you know how the Federalist Society has people come and speak, and they usually do a debate with the professor? And these people travel around the country to do debates on really cool topics. Ken is the person who gets to travel around the country and do those debates. Now, I believe that the reason that FedSoc is the most popular organization at the law school is because of these intellectual debates, or because they can afford to bring in Chick-fil-A for lunch. It's one or the other, I'm not sure. What are you doing now? The one you're speaking at next, what's the topic?
In Toledo, next week at the University of Toledo, the debate is capitalism moral?
The morality of capitalism, I love it. So Ken sent us a little blurb, and he told me that if I wanted something a little bit different about him, and I quote, "I am a lifelong, faithfully committed fan of the Cleveland Indians and Browns. Over the years, that commitment has taught me humility and the limitations of the human endeavor. Perhaps it has strengthened my character." All of you know that I'm a Cubs fan. Let me say no more about humility and the strength of character. Our next speaker is Professor Bridget Dooling. She also came from the public sector as Deputy Chief of the Office of Management and Budget and the Office of Information and Regulatory Affairs. She's now a research professor at George Washington University, where she got her bachelor's degree. Professor Dooling got her JD degree at George Mason and has taught a course there on regulation. She's a regular contributor to one of the top online blogs in the country, the Yale Journal of Regulations Notice and Comment blog. When I contacted her about her travel arrangements, she asked if she could get back to me because she was going to a professor's conference in New Orleans. And I said, well, you can, so long as you have some beignets for me. And so she has assured me that she has fulfilled her duties. So I also tell you that when we asked her an interesting fact, she is a beekeeper. And so is it more dangerous to be a beekeeper or to get up and speak on Professor Lambert's book in front of him? I'll leave that to you. Our third speaker is Dr. James Brohl, who had to tell me at least 4 times how to pronounce his name. He's a senior research fellow at the Mercatus Center, which is part of the George Mason Law School. Now, some of you might know that the George Mason Law School is now the Antonin Scalia Law School. It was the Antonin Scalia School of Law. Antonin A, Scalia S, School S, Law. So it was the asshole School of Law. And so they had to change it to law school. And I think they had like signs printed, and so they had to change all of that. For those of you students who love research and writing and policy analysis, you want to know the coolest job that you can get? It's what Dr. Brohl does. He writes policy briefs and op-ed pieces across the country. He's been published in the Washington Post, U.S. News, and as my husband calls it, U.S. News and World Distort. And his interesting fact, his interesting fact is the most interesting of all. He took a rather circuitous route to economics and he got his PhD in economics from George Mason. I forgot about that. Okay, blah, blah, blah. And is our only non-attorney speaker as well. So he has taken the most circuitous route to becoming an economist and a public policy expert. He was in an indie rock band and played bass in New York, had several, I guess you had an independent label that picked you up, and you toured several times in the UK, and then the band fell apart, and what do you do after you're in an indie rock band? You get a PhD in economics. So he's our third speaker. And the poor fourth speaker doesn't know what I'm going to say because he was one of my students. So Justin Smith graduated from the University of Missouri Law School of the Midwest, University of Missouri, in 2010. I hoped when he was in law school and took advanced tax classes that I was going to lead him on the route to fame and fortune as a tax lawyer, but no, he went to the dark side and became a litigator at Chicardi and Bacon. But as a litigator at Chicardi and Bacon, he got to work with somebody that some of you have heard of, Lawrence Tribe, who also is at the University of Missouri of the East, Harvard Law School. I think that you opposed the Clean Power Plan. That must have been really cool. A new associate. You got to work with Larry Tribe. When Governor Greitens became governor in 2016, he was appointed at the ripe young age of, I think, 12, to be the deputy general counsel for the governor. And it's that role that brings him here today. He was tasked with updating and revising and revamping the Missouri regulations, the Missouri Code of Regulations. He is now the Special Assistant Deputy Attorney General for Special Litigation in Missouri, and does all sorts of cool projects, some of which you might talk about. The interesting thing about him, which is not so funny but very touching, is we had a scholarship banquet one year, and we brought all the donors in who who gave scholarships, and Justin spoke about how the scholarship that he got transformed his legal experience. He didn't have to work, and he had 5 brothers and sisters, and like there was not a dry eye in the place. So I was very proud of you, and that's what I remember about you most. So without further ado, Ken Davis.
Well, thank you for that very kind introduction and the invitation to participate in this important conference based on this extraordinary book by Professor Lambert. I should note in response to part of the introduction that with the resurgent Browns out, I was happy to root for the Chiefs. A lot of good that did. All the views that I have this afternoon are my own and not associated with any client or past employer. I am delighted to participate. Even listening this morning, I was delighted to be advised by a fellow panelist that my mental capacity is comparable to that of James Madison. We shall see. You shall see, and you be the judge. But in all seriousness, it's a serious subject that we're about. How should regulatory procedures be structured to achieve substantially sound, effective regulation? So what are the attributes of sound regulation? Well, a lot of the focus this morning was on costs and benefits and the prudent, thoughtful process described in the book designed to minimize error costs and decision costs while maximizing benefits. A lot of the discussion this morning and the focus of the book is about making regulation sound in the sense of efficient. And certainly sound regulation is and must be efficient. But efficiency isn't everything. There is more to sound regulation. Regulations, of course, have the full force and effect of law, the same as laws enacted by Congress. In fact, regulators enact many more laws than Congress does. In 2016, for example, agencies enacted 18 times more laws than were passed by Congress. So it's vitally important that regulations and procedures, the procedures that are followed to develop the regulations and implement them, are lawful as well as efficient. So what are the attributes of lawfulness? Well, one necessary attribute of lawfulness certainly is statutory compliance. That is, the regulations and the procedures followed to enact and apply them must be in complete and consistent compliance with all the applicable statutes, the enabling statutes as well as, for example, the Administrative Procedures Act, and all the controlling court decisions that have interpreted those statutes. Now, as we all know, enabling statutes are typically, these days especially, typically broadly written. So it falls to the President, his agency heads, groups like OIRA, and the courts to police the boundaries of statutory compliance. And occasionally it falls to Congress as well. Some recent examples of this sort of compliance, statutory compliance, boundary policing include Administrator Rao's robust stewardship of OIRA, the growing criticism of Chevron and our deference expressed by Supreme Court justices, and the cert petition, for example, granted in the Kaiser versus Wilkie case to review our deference. Also, steps by the administration, including the Department of Justice, to restrict the scope and use of agency guidance to genuine cases of guidance and not the enactment of new legal requirements in the guise of guidance. And as for Congress, the application by Congress of statutes such as the Congressional Review Act and the proposed legislation like the REINS Act. More broadly, I would suggest that Congress really needs to go back, if it can summon the will, to revisit comprehensively the 1946 Administrative Procedures Act. Much has changed since then. But there's more to lawfulness than statutory compliance. A second fundamentally important attribute of lawfulness is compliance with the fundamental law of our republic that is embodied in the Constitution. The Constitution, with its provisions interpreted to faithfully conform to their original public meaning. Now, the founders were well acquainted with the abuses of consolidated executive power. In these sufferings, their sufferings, they found proof of the wisdom of a government of enumerated powers, separated functions, and reserved rights, a structure enacted to secure the natural rights, including the property rights, of a sovereign people. Three branches. First, an avowedly political legislature, the people's representatives endowed with the authority to enact new rules of general applicability prospectively, typically proscriptive rules, to remain in effect until amended or rescinded by the people's elected representatives acting in response to changed circumstances. An executive, also responsive to the people, tasked with ensuring that the rules enacted by the legislature are faithfully executed. A judiciary, thirdly, comprised of individuals insulated from political pressures, tasked with the job of interpreting the law as it has been written and applying it retroactively to resolve past disputes. Three branches, different functions, different decision makers. We all know this, and at least our system of governance used to know it. But through this constitutional structure, the founders sought to establish the rule of law in our new country. Now, the rule of law is not to be confused with the mere existence of laws and the institutions commonly associated with the legal system. Countless laws have, of course, been promulgated and enforced by tyrants over the years. Dictatorial systems typically have written constitutions and bills of rights. And did you know North Korea has a professional bar association? The rule of law, different from the existence of laws, can be said to exist only if and to the extent the laws and legal institutions of a country operate effectively to restrain the arbitrary, discretionary exercise of authority, unbounded authority. And by doing that, effectively protect the fundamental human rights of the country's inhabitants. A lot of people have written, a lot of academics, commentators have written very eloquently and in great detail about the elements of the rule of law. Richard Epstein, Lon Fuller, Neil Ferguson, Hayek, of course. But this was the system established by our founders' Constitution, to protect the fundamental human rights of the country's inhabitants, to respect and protect their natural rights by leaving them alone within broadly defined prescriptive fencing, out-of-bound markers, so they could pursue their lives and happiness as they might define it, enjoy their liberty as they might define it, and enjoy certainly the use of their property. Free to make their own assessments of marginal costs and marginal benefits, free to drive their car at a speed up to the limit that they understand based on the information that only they possess that best suits to the facts and circumstances of their particular case at the particular time. Poland, right after the fall of communism, 89, I think, when their newly post-communist assembly first met, their legislative assembly first met, their first law they passed, H.R. 1 we would call it, was short and to the point. It said, everything is permitted unless it is prohibited. They were seeking to turn the page and, in their own way, establish the rule of law as defined by the elements that I have sought to summarize that are embodied in our founding system. Now, even a cursory evaluation of the current regulatory system and the consolidated administrative state shows the dramatic extent to which regulation has forsaken this rule of law as defined. Much of what is concerning about the current system, the consolidation of once separate functions within a largely unaccountable fourth branch, the constantly changing rules, the rules shaped by lobbyists to pick winners and losers, the endless maze of litigated permitting, the retroactivity, the waivers, and the abiding uncertainty that results in the minds of the regulated entities from the broadly defined discretionary authority of individual regulators. All of this is directly traceable to the lawlessness of the current regulatory system. Lawlessness, I know, strikes the listener as a strong term. A few years back, Philip Hamburger, a Columbia Law School professor, wrote a book, a lengthy book, about the history of the development of classical liberal political systems and our early history in the administrative state, and the title was, "Is Administrative Law Unlawful?" It was a rhetorical question, which he answered, unfortunately, in the affirmative, again, based on these principles of definition. But the essence of the rule of law is the restraint of discretionary power as it might otherwise be exercised by private or public figures. The essence of the current regulatory system, with its delegation, deference, and broadly defined standards, the essence of the current regulatory system is the exercise of discretionary power by unelected executive branch expert technocrats. Now, the title of the program is well chosen, I think, Protecting the Public While Fostering Innovation and Entrepreneurship, First Principles for Optimal Regulation. And I'm suggesting that in addition to efficiency, lawfulness is an important, a fundamentally important characteristic of optimal or sound regulation. And if the goal is to improve regulation and seek to work towards sound regulation, that must be lawful. Therefore, the path to better regulation will be marked by reforms, I submit, that seek to restore, or at least in step-by-step process, be guided by the elements and inspired by the elements of our constitutional system of governance, separation of powers, restraint of discretionary executive power, political accountability, respect for property rights among the respected and recognized natural rights of the sovereign individual. So, What might some of those reforms look like? I certainly have not done enough work on this to set forth the outline of a comprehensive system, and I know there's a lot of issues, but I'm just wanting today to sketch some of the elements, some of the reforms, some of the procedural changes that you might consider seriously if you want to move back to the constitutional system of the rule of law as our founders established it and as I have sought to define it and describe it. First, for example, regulatory analysis typically, maybe always, begins with an examination and identification and definition of the market failure that must be responded to, the market failure that must be responded to. And I'm always concerned by the use of that term because I think it sets up a one-way ratchet-like presumption that what's going wrong here is something that is insufficiently regulated or unregulated. There's a gap. Some nefarious characters or institutions fell through the gaps, slipped through the gaps, but now will pass additional regulation and close the loopholes. Well, the economy these days is so pervasively regulated. I think the concept, the analytical anchor of market failure is not only unfortunate for the reasons I argue, but it's simply not accurately descriptive. And it would be better to begin the regulatory analysis process focusing on the concept of regulatory behavior. What's wrong somewhere in the current system? Because every private actor, every profit-maximizing corporation is simply responding to, well, typically responding to and trying to weave their way through and maximize their commercial outcomes given the complex set of rules they're already faced with. All right, another possible reform, subject matter statutes enacted by Congress that use expressly stated rules to proscribe prohibited conduct. The conceptual statutes so typical today contain standards, not rules, but standards that delegate authority. They are, by being standards, designed to delegate authority to regulators to determine the adequacy of conduct as against the standard as determined and applied by the regulator in the particular case. Such standards like just and reasonable, or sufficient, or adequate, or the public interest, or all that business in the net neutrality presentation this morning. All of these broadly defined, poorly defined delegating standards fuel endless delays, disputes, rent-seeking, lobbying, wasteful litigation, and a diversion of otherwise productive resources. In 1928, the richest metropolitan locale in the country was Detroit. 1928, the wealthiest metropolitan area in the entire country was Detroit. 90 years later, the wealthiest metropolitan area in the United States is Northern Virginia, right outside Washington. The bedroom community for the lobbyists and others, but the lobbyists involved in the adjudication and litigation and interpretation of these broadly defined standards. And I was talking about prescriptive rules should be the goal. Prescriptive rules that permit anything that is not prohibited, like the polls were after, rather than prescriptive means and method regulation so typical today that seeks to manage conduct and allocate resources. Prescriptive rules, leaving everything else open, would be more consistent with the reality of Hayek's dispersed information and with the free markets, the efficiency of the free markets essential to prosperity. Prescriptive rules would lessen the need for concern about the trade-offs between error costs and decision costs. Regulation based on prescriptive rules would also, perhaps down the road, permit a repurposing of expert technocrats from the decision makers they are today in the process of applying standards to perhaps a more appropriate role as people, as experts who provide input to the congressional legislative rulemaking process, which is set about to enact rules. Now, another sort of reform, going down the sort of the list here, the abbreviated list, headline list, maybe clickbait list here of rules, of possible reforms. Another sort of reform might be to place restrictions, procedural restrictions on the ability of regulators to grant coverage and compliance waivers to regulated entities. Here again, such waiver authority is a throbbing invitation to rent seeking, and it's typically big money rent seeking that places the smaller companies in the sector who might otherwise be in a better position to compete with the larger firms. It places them at a great disadvantage because the ability to expend the money to get the waiver is one more expense that smaller firms find harder to meet. But waivers from the executive branch are an old problem. Following the Glorious Revolution in England of 1688, there was a settlement drawn up between Parliament and the new king in which he promised to do certain things and not to do a long list of things. And one of the things in the settlement document list of 1689 is that the king promised to refrain from selling dispensations and exemptions from laws passed by Parliament. Another reform could be in the form of legislation to expressly toll, think about this, expressly toll all compliance deadlines contained in new regulation until any challenging litigation has been completed on the merits. This to end fait accompli rulemaking that's sometimes used by aggressive agencies to effectively deny regulated parties their constitutionally guaranteed right of due process and meaningful appeal. Now, a striking example a couple of years ago of this, the mercury and air toxics rulemaking, which was litigated by the utility industry, ultimately successfully, but because of the interim compliance deadlines contained in the rule as finalized by the EPA, the appealing companies, especially considering their capital-intensive nature of their operations, were faced with an awful dilemma that if they lost the litigation, then they would be in further trouble because they couldn't meet the interim deadlines because they had deferred those expenditures pending the outcome of the litigation. So, toll the compliance deadlines. Benefit cost analysis is an important part of the regulatory process. One change I would put on the wave the wand list would be to recognize that restrictions on consumer choice that are the target of so-called nudge regulation, that restrictions on consumer choice are costs, and restrictions on consumer choice are not to be counted as benefits resulting from the imposition of a new rule. Finally, we might imagine the possible positive impact of looking at benefit cost regulation and backstopping the whole process. The indeterminate, always inconclusive, always disputed benefit cost analysis process, backstopping it with legislation that would grant a 100% refundable transferable tax credit for the compliance costs incurred by the regulated entity. It would be a self-funding tax credit if it was in fact the case that the economic benefits accruing to society as a whole, the benefits exceeded the cost of complying with the regulation. There wouldn't be any net cost to the economy. Okay, just headlines. This is not obviously. This is not a system. Okay, but these are thoughts, and this is what I'm really after, is to hope that you'll take away here when you consider how to make regulation better. You'll think about the constitutional system of our founding and the separation of powers and how that differs from the current structure and process that's produced by that structure now. And if you want to move in that direction, then you would consider things and then think about how they might be implemented. Consider things like reducing the discretion of an individual. How would you reduce the discretion of an individual regulator in an individual case and so forth? But again, it's just a sketch based on principles. First principles, perhaps, I'd say, embodied in our Declaration and Constitution. Now, as a Virginian, I'm proud of our founders, but I'm not motivated in all this, what I say about some sentimental desire to return to some imagined, idealized golden past, but really by a genuine conviction that the best way forward to a prosperous, innovative future is to recognize the political and economic primacy, the sovereignty of the individual as we look at the current regulatory system. Now, it's not all bad. I'm not suggesting that the current system is all bad. To borrow and reapply or differently apply a phrase, I'd say that you look at the current regulatory system and it's mixed bag behavior. And so we're all about looking at the regulatory system and the regulators and seeing how we can get out of them and their expertise more good and less bad. And in those musings and thinkings that you have in your future jobs, you would be well served to be guided by the thoughtful, detailed, articulate book that is the subject of this conference. But it's an exciting prospect for you 3 Ls and 2 Ls a little bit later as you go forth. The temptation will be, as a matter of human endurance and limitations of every day, to be a well-paid, competent dial turner in the law firms serving the clients who are regulated by all these agencies that we are talking about today. Certainly, I spent a lot of time and bought a lot of groceries over the years turning my dials for my clients. But as lawyers and citizens, we have a responsibility to try to do more than that if we possibly can. And again, this book gives such a good roadmap for a responsible endeavor of that nature. Thank you.
To push. Okay. Thanks, Ken. That was a great introduction to this panel. I'm from New York. Ken's from Richmond. We're going to talk a different tempo. How we were raised. I'm Bridget Dooling. I'm a research professor at the GW Regulatory Studies Center. I'm so happy to be here with you all today, and big thanks to Professor Lambert for inviting me. The GW Regulatory Studies Center is an applied research center, which means we take scholarly ideas and we apply them to real-life regulatory issues by writing public comments to regulatory dockets, by compiling statistics, writing reports, contributing articles to very fine academic journals like BETR, of course, and of course speaking at fine symposia like this as well. And today it's a twofer because you saw my colleague, Dr. Jerry Ellig, speak this morning. On this morning's panel, I will not be singing today, though, so just to set expectations a little lower, that's not a standard GW Regulatory Studies Center offering, singing. Yet. Okay, so we're going to work on that, I guess. I'm going to talk to you today about something that I'm calling bespoke regulatory review. For those less familiar with the term, bespoke is a term from fashion. It refers to clothing that's tailor-made rather than that which is mass-produced. And now perhaps you don't often think of high fashion and regulatory review as having much of a nexus, but that ends today, okay? So let's get into it. Let's start with a roadmap, because I always like to know where I'm going when someone's talking to me, so let's do that for you. This panel is all about procedures for ensuring optimal regulation. My background is that I served for over 10 years as an analyst and deputy chief in the Office of Information Regulatory Affairs, which we call OIRA. My job there was to review draft regulations before they were made public, and I did that by applying our federal government's regulatory policy, a sort of policy on policy. With these policies, many folks have argued they're the best ones we have to ensure optimal regulation. So we'll start there with a crash course on what those standards are that apply to creating or altering federal regulations. After that, I'll share with you that not all agencies are subject to these standards. In fact, the handful of agencies known as the independent regulatory agencies are carved out. I'll suggest that one way to ensure optimal regulation is just to do more regulatory review, particularly regulatory review of the independent regulatory agency rules. But I'll raise for you some of the complexities of doing that. And then, just when you are full of despair, I'll offer something as an idea that could help, yes, bespoke regulatory review. So first, what is this regulatory review policy, this policy on policy I referred to earlier? Reg review is primarily governed by Executive Order 12866. We know presidents issue executive orders, and this one is no different. It gives agencies goals and principles for regulations. It's quite a high-minded document. It asks them to identify the nature and significance of the problem that they're trying to solve with their proposed regulatory action. This is where we get at Ken's market failure question, right? Is there a market failure, a government failure, or some other systemic problem that makes the government think that it needs to act now to intervene? Next, it asks the government to identify and assess the alternatives of different ways to solve the problem that it's identified, and then to assess the costs and benefits of each of those alternatives. And then once you've looked at all those, to select the option that maximizes net benefits to society. And the Office of Information Regulatory Affairs, OIRA, where I used to work, oversees agency implementation of this policy. So if these principles sound fairly reasonable, it might surprise you that not all agencies are subject to them. In fact, there's a small number of agencies called the independent regulatory agencies that are carved out. It includes big regulatory agencies like the Federal Communications Commission, the Securities and Exchange Commission, the Consumer Product Safety Commission, and I could go on, but please don't make me because there's just so many acronyms and government-sounding names. But there's a list and you could look at it, and if you're curious, I can show you later. I understand this to have been something of a political compromise because the independent agencies have structural features and authorities that set them apart from other agencies. and any intrusion into their domain can raise alarms, especially if that, that intrusion is done in a one-size-fits-all manner. One big difference between independent agencies and others is that the heads of independent agencies often cannot be fired by the president without cause. That's different from, say, the head of a cabinet agency, which the president can fire at will. Independent agencies are also often organized into multi-member commissions or boards rather than a single head. And they have term limits for these seats that don't all coincide with the presidency. Sometimes there's even partisan balancing restrictions, meaning there might be a set number of seats for Democrats and a set number of seats for Republicans, no matter who the president is, who's allowed to appoint them. Some of them also have the ability to generate their own funding through fees and other mechanisms, and others can bypass OMB's budget process and go straight to Congress for appropriations. The independent agencies as a class, they're just not monolithic. They all have their different features that add up in the end to more or less independence. But let me show you what that looks like in practice if you're a regulated entity. So I gave myself 2 minutes to brainstorm a bunch of regulated products or services, and then I divvied them up between those agencies that are subject to Executive Order 12866 and those that aren't. Now, this is obviously just a tiny snapshot of the products and services that are subject to federal regulation. It's basic, it literally is a 2-minute brain dump of mine, right? So you couldn't fit all the regulated products and sectors onto a slide if you tried. Now, but I don't know about you, but it's not immediately obvious to me why air transport regulation should be subject to Executive Order 12866, but ocean transport rules should not, right? Same with cell phones and medical devices, and on down the lists. We ask for a regulatory impact analysis when it comes to endangered species, but not nuclear power plants. I mean, you just can't reconcile this. There's no sort of principle that runs through sort of which gets handled which way. The distinction is only which type of regulator produces the regulation and has jurisdiction. So as a result, over the years, scholars and practitioners alike have looked at this exemption. A constantly lurking question is whether independent agencies are even constitutional in the first place, right? We have 3 branches. We got a reminder in Ken's presentation. We have 3 branches, so where do these independent agencies fit in, right? If the president can't fire them, what gives, right? How should we think about them in terms of our structure of government? Now, thankfully, I don't have to do much resolution of that for me to move forward in my inquiry, because for my purposes, all roads can lead to a WIRA review. If the independent agencies are not constitutional, well, that's the easy case for what I'm talking to you about, because they can just be swept into a WIRA review like the others. But if they are constitutional, we have other practical questions to consider. Why would they ever agree to be subject to a WIRA review? What's in it for them? If there's disagreement between OIRA and the agency, what then? If the agency resolution, for other agencies, resolution can occur between that agency and the White House. But how does that work if the president can't ultimately threaten or actually remove the head of the agency over a dispute, right? They reach a stalemate, and where do we go from there? And at which level of the agency should OIRA even engage? Should they engage with the chief commissioner, if there is one? Should they engage with the entire board? Should they engage with the executive director, with the career staff? It's just not clear what the point of entry is for an agency like OIRA to engage with an independent regulatory agency. Also, the independent agencies are often subject to Sunshine Act provisions that require disclosure of certain documents. There would be a very different type of process from the way OIRA functions with the executive branch agencies, because those functions occur behind the curtain of the deliberative process privilege, meaning that its materials are not automatically subject to disclosure. And this is only just a few of the looming practical questions. There are surely many, many more. So are you now feeling some despair? Good, then I'm doing my job. So I want to offer you an idea that could help, what I'm calling bespoke regulatory review. So let me explain. OIRA recently negotiated a memorandum of agreement with IRS, the Internal Revenue Service, to subject certain tax regulations to OIRA review. Now, these had been carved out a while back, and this agreement signaled a new phase in the relationship between OIRA and IRS. IRS is not an independent regulatory agency, but it has been able to function a bit like one when it comes to its regulations. And the terms of the agreement differ from the text of EO 12866, which otherwise sets the terms for regulatory review, in several intriguing ways. First, the preamble of the MOA reminds us that the agencies, in this case OIRA and IRS, were at the table because the president told them to go there. The president told them to revisit their arrangement. He did that in an executive order that set the stage for the MOA's issuance later. Second, it adjusts the standards for which governments have to come into OIRA for review. It's a test known as the significance test. And in the case of the IRS MOA, it says, for example, that only actions promulgated pursuant to Title 26 of the US Code are in scope. You'll know more about that than me, what that includes and what that doesn't. I'm not a tax prof, but there's nothing like that in EO 12866. There's nothing that sort of narrows or widens the scope in terms of the particular subject matter in that way. Third, it sets a more aggressive timeline for review, shifting from EO 12866's default of up to 90 days to a presumption of no more than 45 days. Fourth, it has a dispute resolution clause that articulates a particular pathway through the White House. They say to each other, if we disagree, here's how we're going to handle that. Here's what that process looks like. That's written in the MOA itself. Fifth, it includes a phase-in, which allows IRS to take up to 1 year to ramp up its capabilities. And there's nothing like that in EO 12866 right now. Overall, to me, it serves as an example of a negotiated, tailored, yes, you could even say bespoke, agreement between these two entities, which each apparently had enough power that neither could outright control the other, because if they did, you wouldn't need an MOA. The reason I think this offers some potential as a way forward with the independent regulatory agencies is that it offers a way for the president to acknowledge the independence of these agencies while still taking a step forward. For example, the preamble's idea. If the president issued an executive order directing the independent regulatory agencies to negotiate with OIRA, or even just directing OIRA to negotiate with them, perhaps they'd come to the table, because that's a smaller ask than subjecting them to OIRA review outright in a one-size-fits-all manner via executive order, which is the approach that's more often discussed for how to call these agencies in. The MOA approach also offers a way to fit OIRA review to the particulars of each agency. As I mentioned before, independent regulatory agencies each have their own particular structure and circumstances and statutory authorities and ways of operating that might counsel for different provisions of review. And one of the main practical concerns independent regulatory agencies might have about OIRA review is that maybe they lack the staff and expertise in applying these principles of economic analysis because they haven't so much needed to do them up to now. So the phase-in offers some help there, perhaps a more structured phase-in, perhaps even agreement about the type of technical assistance that OIRA could provide during that period of time. It also offers a way to tailor something like dispute resolution. The big looming brinkmanship question in all of this is, what happens if it goes all the way and the president can't ultimately threaten to fire the head of an independent agency? Well, by negotiating an agreement about how they'll handle disputes, maybe you sort of push the consideration of that brinkmanship out a few steps, so you don't go straight there. Maybe you have some ways of navigating disputes. That question can't be resolved in this way, the ultimate question, but at least if you give folks a couple steps of escalation, it may help them feel like, okay, we can at least give this a go. One obvious criticism is that this could lead all agencies to request a tailored agreement as well, resulting in an avalanche of requests that OIRA would have to deal with. And I'm sure there's lots and lots of other reasonable concerns too. but I'd be remiss if I didn't at least hold up the model and see if it might be a way forward on this question of independent agencies and regulatory review. Even incremental progress in the form of negotiated MOAs could be a game changer. Thank you.
Yep. Here we go. All right, the focus of my remarks is on regulatory reform in the states. Now, I would argue that there have been three major waves of regulatory process reforms over the last 75 years. The first started in 1946 with the passage of the Administrative Procedure Act, as we heard about earlier. In the following decades, most states, virtually all states at this point, adopted some version of an Administrative Procedure Act that set up a process by which regulations are put into place. Usually regulations are first proposed, comments are taken from the public, and then they're finalized. The second major wave of reform started around the mid-70s, but really kind of took hold in the early 1980s, and that was when we started seeing cost-benefit analysis requirements for regulations. Reagan had a famous executive order that required cost-benefit analysis for major regulations. Many states, I think every state but maybe one state at this point, has some requirement in place for cost-benefit analysis. However, the states are way behind when it comes to the quality of this analysis. For the most part, it's a check-the-box exercise. It's a 2- or 3-page form that's kind of added on top of the regulation when it's filed. I would argue right now we are in a third phase, and that is the phase of regulatory budgeting. Now, it sometimes goes under the more informal name of kind of red tape reduction schemes or regulatory reduction efforts. And they vary in complexity from jurisdiction, but that's the focus of my talk. We've seen that President Trump's executive order that he signed, 13771, I believe, when he first came into office, kicked off the first regulatory budgeting scheme in the federal government, and now there are a number of states that are experimenting with these reforms as well. Now, why do we need regulatory budgets? Why would this even be an issue? We have cost-benefit analysis, right? Well, the reason is this issue of regulatory accumulation. There's a natural tendency every year for more regulations to get added to the books than are taken away. It's the job of regulators to write regulations. That's their job. They're not deregulators, although some states have experimented with offices of the repealer and things like that. But regulators write rules. So we get more regulations over time. We get more restrictiveness. And we saw Professor Lambert talk about how as we get more and more restrictiveness, we can get to the kind of the inefficient point where the marginal costs exceed the marginal benefits. The benefits are kind of going down, the costs are rising. I have colleagues at the Mercatus Center who have estimated the effect of federal regulation on national economic growth. Now, they estimated that federal regulations since 1980 have slowed growth by about 0.8 percentage points a year. That doesn't sound like a lot. It's less than 1%, right? Sounds like nothing. Okay, but over time, due to the compounding effect, as growth rates are slowed, this can add up to trillions. All right, so they estimated that if we had capped the amount of regulation in place in 1980, so said not no new regulation, but just for every new rule, we're going to take an old one off the books. We're going to find an old one that's outdated, ineffective, inefficient, fails a cost-benefit test, and take it away. That by 2012, the US economy would have been about 25% larger, which works out to about $4 trillion, which in 2012 was bigger than the economy of Germany and France. Okay? We're talking about losses to the economy. They're the sizes of the GDP of entire developed nations. And it works out to about $13,000 per capita. Now, obviously, there's a great deal of uncertainty in any study like this. However, there's quite a few peer-reviewed academic articles at this point, it's expansive literature, I would argue, especially in the cross-country context. And these estimates are really very much within the mainstream and may even be on the low end, okay? There are estimates that are far higher, 2%, 3 percentage points slower annual growth. Missouri last year grew about 1 percentage point, real GDP, 0.9%. Over the last decade, annualized growth of 0.4%. So this is considerably below the national average. I think the nation grew at 2.2% last year, and or for 2016 to 2017, and maybe about 1.5 percentage points annualized. So Missouri's growing slower than the national average, but in fact, the nation is growing slower than we used to, and virtually every state is growing more slowly than we used to. Than in the second half of the 20th century, there's been a slowdown in productivity growth. There's been a slowdown in wage growth. There's been a slowdown in GDP growth, okay? And just adding 1 percentage point even to growth each year adds up enormously over time, okay? So if Missouri continues growing at 0.9%, or roughly 1 percentage point a year, it'll take about 70 years for the economy to double in size, so nearly a lifetime, okay? If you could increase that to 3%, now that doubling time falls to 24 years. So in a lifetime, rather than double once, you might double 3 times, okay? So the economy would be 4 times larger. That's a lot, and you know, people don't eat GDP. It's not like we care about GDP as a statistic, but we care about the wealth that it brings, the opportunities it brings, the improvements in technology, in education, in healthcare that accompany wealth creation. So this is why we need some sort of system to control regulatory accumulation. We also budgets need a measure of regulation. So I'm involved in an effort at the Mercatus Center to quantify regulation. And what we're doing is we're using text analysis to analyze state regulatory codes and the federal code. We began with our Reg Data project began looking at federal regulation. Over the last couple of years, I've been extending this to the states. Our measure of regulation is fairly simple. We count up what we call regulatory restrictions. These are instances of words like shall, must, or required that can signify some sort of mandate, prohibition of some kind. We count up the number of words in codes. We can figure out which industries are targeted by regulation by looking for keywords relevant to those industries. And what's unique about this data set is that we now have a common metric that we can apply across many jurisdictions and start comparing how much regulation different states and the federal government have relative to one another in a common metric. We've looked at about 30 states so far, and we should be finished with every state that's feasible by the end of the summer. Some states we learned, like Arkansas, doesn't even have an administrative code. So no one in Arkansas has, Bill Clinton or whoever has been the governor, I mean, you'd think somebody would have figured this out at some point. Maybe you put all the rules together in one place and then publish that. No, there's just basically a register where they publish regulations as they're finalized and they're not compiled anywhere. Fortunately, they're in the process of correcting this issue. But every state will be able to get through, I think, by the end of this summer. We've looked at about 30 states so far. Missouri has, as of 2017, these numbers may have changed in the meantime, had 113,000 of these restrictive terms in its administrative code. To put that in context, New York has the highest level of regulation we've seen so far, with about 307,000 restrictions, and Idaho has the lowest level with about 61,000. And interestingly, Idaho, just in the last month, has begun the implementation of a regulatory budgeting kind of reform and put in place a 1 in, 2 out policy, similar to President Trump. So they're actually kind of aggressively targeting reducing their regulations right now. Now for each of these, each state that we look at, we put out a report where we summarize some of the key data that we've captured as part of our our text analysis. So we found that, so if you're interested in the Missouri Regulation Snapshot, as we call it, you can look it up. You can just Google Missouri Regulation Snapshot. It's freely available, as is all the data on the Mercatus website. So it would take about 10 weeks to read the Missouri Administrative Code. But as Justin's going to talk about in a couple minutes, these numbers may have declined somewhat. So some states are, as part of their regulatory programs and reduction efforts, are actually using our restriction count measure, and Missouri has been one of them. And so there may have been some changes in these numbers, and maybe he'll get into that. We look at which industries are the most regulated. In Missouri, it was utilities, healthcare services, various kinds of manufacturing, food production, oil and gas, to some extent, probably hospitals, some of the industries you might expect. Biggest regulator in the state, the Department of Natural Resources, with about 24,000 of these regulatory restrictions just in its title. And it's fairly common to, as we look across states, it's usually environment and health-related regulation that are kind of the dominant forms. Occupational licensing can be pretty high up there too. Sometimes there isn't a separate title for occupational licenses. They're kind of spread across many different titles, so it can be hard to identify them all. Okay, so what's going on in the states right now? So the first thing I would say is that surprisingly, the Canadian province of British Columbia, Canada, seems to have been a major source of inspiration for regulatory reform and regulatory budgeting in the United States, especially at the state level. So you might be surprised to hear that Canada has been kind of at the forefront of regulatory reform, but it turns out to be the case. The United Kingdom is probably another example. The United States, for a long time, was kind of the leader in regulatory reform, setting up administrative procedures and cost-benefit analysis, and other countries were copying us. The situation's kind of reversed now. We're sort of following other countries' lead. British Columbia, surprisingly, was able to cut their regulatory code book in half over about an 18-year period. So that since 2001, they've reduced their regulatory requirements by 49% as of the last estimate. Okay? If you look at the US, especially at the federal level, it's pretty much just a relentless rise in growth in regulation over time. We had about 10,000 pages in the Code of Federal Regulations in 1950. Now it's 186,000, I think. We had about 400,000 restrictions in the Code of Federal Regulations in 1970. Now it's about 1.1 million. So British Columbia went the opposite direction. They cut their code book in half. How did they do it? Well, they used a simple measure of regulation, right? They decided they were going to measure how much regulation they had in place. They counted up all the regulatory requirements that they had on the books. Now, this simple measure, much like our restriction measure, you know, an economist might say, well, you know, one restriction will have much more bigger impact, or another restriction might have a lower impact, and there's no doubt that's true, but there's a trade-off that happens between the complexity of the regulatory measure and how broad your reform can be, how broad your regulatory budget can be. The Trump administration is finding that they're using opportunity costs to society as their measure of regulation, and it's limiting the scope of the number of regulations that are falling into their budget. At most, it's maybe 8% of regulations that need to be offset under their 1 in, 2 out policy. Those are the significant regulations that are reviewed by OIRA. But for practical purposes, it's probably even fewer than that, because so few regulations have credible cost estimates in order to even make the determination of whether a regulation is offset or not. They used a simple measure. They counted up how many requirements they had in place. It's about 380,000 at first, the first count. They had interns do this work initially. Eventually it became kind of more formalized, but that was how it started. They set a 1/3 reduction target. They said in 3 years we're going to slash 1/3 of our requirements. Interestingly, They were so comprehensive, they looked at regulations, they looked at policy documents, and they even looked at statutes. So they counted requirements in all of these things to bring it all into their budgeting process. For over a 3-year period, they cut a third of their requirements. At the end of that time period, they put in place a permanent cap, a one-in, one-out policy, and that's been in place since 2004. So this is one of the longest lasting, I would say, certainly regulatory budgeting systems in North America or in the world. And it's survived different administrations and different political parties in charge as well. And now this British Columbia model has inspired a number of regulatory reduction programs in different states. So no more red tape, which we're going to hear a little bit about, is one such effort that also was using our restriction count measure from the Mercatus Center to count up, to sort of track how many restrictions they had on the books as they were reviewing the code and trying to find rules to eliminate. Illinois also was using the restriction count measure. Kentucky's had a red tape reduction effort ongoing for a few years now. Arizona had regulation rollback. I would say there's probably 5 or 6 other states that over the last decade have had, so in one manner or another, some kind of red tape reduction effort. Some of them they've, to varying degrees, they've had elements of this regulatory budget. So some of them had an initial count of restrictions or requirements. Some of them had this reduction targets or one-in, one-out policies. But these efforts in particular have been kind of temporary efforts. Usually a governor has come into office, kick-started a red tape reduction effort, and then it's ended when their term ended. Something more permanent, which I think is really the model maybe that we should be looking at in the States, is Virginia's 2018 Regulatory Reduction Pilot Program. So Virginia, obviously we know, is having some issues currently with its governance. But I don't expect that to have any adverse consequences on this program. It seems to be going kind of unabated. One of the really striking things about what happened in Virginia is that their regulatory reduction program was so bipartisan. It was signed into law by Ralph Northam, a Democrat, passed through a very narrowly controlled Republican legislature nearly unanimously. So how did they do this? Usually regulatory reform is kind of controversial. Well, they did it by initially focusing on occupational licensing. And so this really highlights how sometimes you can have broad-based regulatory reform if you start by tying it to something where there's a lot of consensus. So President Obama put out a report at the end of his administration, his Council of Economic Advisors. It was about occupational licensing and a lot of the problems that can arise from it, how the boards in each state that set these licensing requirements tend to be comprised of industry insiders. They have a strong incentive to keep out competitors. This limits mobility for workers, makes it harder to work your way up the economic ladder. And so there's a lot of agreement across political parties that this is an area where there's problems. So what is Virginia actually doing? Like British Columbia, they put in place a system to count and start tracking and reporting how many regulatory requirements they have in the books. Now they're starting with 2 agencies, the Department of Professional and Occupational Regulation and the Department of Criminal Justice Services. Both engage in a lot of licensing related activity. There's also kind of a criminal justice sort of element to this as well. They just recently, in the last couple months, have started producing their first counts. They had about 6,200 requirements between the 2 of them. And these are somewhat small agencies, actually, within the Virginia government. So I don't think they were in that top 10 list that we produced in Virginia's report. Now, of those 6,200 requirements, 80% of them are discretionary, which means there's no statute that mandates those requirements be in place. There's simply, it's up to obviously a statute authorizes the requirements to some extent, but it's discretionary on the part of the agency whether or not to issue a regulation or not. So by 2021, these 2 agencies have to reduce their regulatory requirements by one quarter, by 25%, as authorized by the legislation. And then in 2020, there's going to be a government-wide count. Every department is going to now have to report how many requirements they have in place. So this is being framed as a pilot program, so it remains to be seen exactly what's going to happen next. I would hope that the reporting, at least, would continue, but it's certainly conceivable that different caps or reduction targets or even letting requirements rise over time, different budgeting levels could be set by agency. So this adds a level of transparency that really hasn't existed before, and it also will help the governor and the legislature gain more control over the output of regulatory agencies. So they have a process for fiscal budgets and appropriating budgets to regulatory agencies, but there really hasn't been any process until now to control the regulatory output. I would also just mention that Idaho is another state. Oh, I did mention that, but Idaho's reforms are somewhat similar to Virginia's. They've also produced a baseline count of regulatory restrictions. They're using the Mercatus measure, and that's all been done through executive order. So it highlights how a lot of these key elements of a regulatory budget really don't require legislation. It would be more permanent with the legislation, but a governor's executive order could certainly establish it. So just to conclude, I would say that there's new data available, simple measures of regulations like Mercatus's restriction count measure. That's available for use in academic research, but also we're finding that policymakers find this data very helpful to track their regulatory reduction efforts. This budgeting system for regulations really seems to be starting to spread across the country in this kind of third wave of regulatory reform like I was talking about. And so I would recommend that states like Missouri and other states around the country really take a good look at what President Trump has been doing, what states like Virginia and Idaho are doing, because these are really fairly simple reforms. They're not expensive. If you look at the fiscal note that was attached to, say, the Virginia legislation, they're very feasible, and you know, your state could be next. You could be the next leader in regulatory reform. And so with that, I would say thank you, and I guess I'll let Justin speak next.
Thanks, James. It's a good segue for my presentation because James really laid the framework for what we've done here in Missouri. So let me just get this pulled up. All right, so James alluded to this before, and I'm going to step out here so I can see the screen a little bit. I'm excited to be here today. Thanks, everybody, for making it through a really good day, and thanks to Professor Lambert and Cecil for organizing this and all the students. I think this has been really terrific. So what I'm going to talk about is what James alluded to in his presentation, what we've done in Missouri to address regulatory reform. We focused on red tape. There's a kind of a stigma when talking about deregulation in a government context when you're trying to work with policymakers. So we've worked on a definition of red tape that's similar to the way Professor Lambert defines regulations in his book. But basically, big picture, is red tape is just those regulations or government rules that unnecessarily burden individuals or businesses without doing a whole lot to protect public health or safety. Working off this definition, we then went through a process beginning in early January 2017 and continuing through today to focus on cutting back that red tape in Missouri. So here's where we're headed, where Missouri was back in January of 17, what other states have done, what Missouri did once we learned from the other state models, and then finally where we're at today, some updates. Beginning with the first point, which James has already largely covered because we used Mercatus's data. We just saw these statistics. Missouri had about 113,000 restrictions. Those 5 key terms that James talked about: shall, must, may not, required, and prohibited. If you count those terms, they show up 113,000 times in the Missouri Regulatory Code. If you started reading today, you'd finish the Missouri regulations about Easter weekend, if you're reading 8 to 5 every business day.
So it would take a long time. We also just saw this from James. These are the top 11 states with the smallest number of regulations. But as you can see, Idaho and Arizona have almost half of the number of restrictions that Missouri had. When we started this effort, Mercatus was still bringing new states online, so we were actually closer to the middle of the pack of the first states that they had done. But what we heard from a lot of folks is, well, we have to have this many regulations because we have federal mandates. They require us to have certain rules in place. And our response would be, well, look at Arizona. They're in the same country. They're subject to a lot of the same rules, with some exceptions, and they can get it done with 50,000 fewer restrictions than what we have. So that can't be the answer. And so working off that, we then tried to figure out how we can cut back that number to be closer to the Arizonas of the world and farther away from the New Yorks and Californias that you just saw in James's data. This is a chart that James didn't show, but it's also Mercatus-based. This shows where Missouri has come from since 2002 through January of 2017 on the number of restrictions. As you can see, it's a steady incline that a number of the speakers have talked about today. Here, what's the most interesting fact that I found when we were preparing to launch our effort is the fact that the number of restrictions in Missouri grew at a faster rate than at the federal level. So Missouri, over that same time period, had a 25% increase in regulatory restrictions. For the federal government, it was 22%. So we hear a lot about what's going on at the federal level and overregulation, but based on this metric that Mercatus had developed, it looked like Missouri was growing at a faster rate than even the federal government that so many criticize on regulatory policy. So this was a key thing that we looked at to say we need to reverse that trend. We need to start going down instead of this constant climb. So before we got going, we looked at other states. We wanted to know what the rest of the country had done in this space so that we could try to design a best of the best type of review where we could borrow from multiple states, combine all that into one program, and then move forward from there. So what you'll see in this slide is all the states since 2010 that have had a governor-launched regulatory review project. They're color-coded by the partisan affiliation of the governor. You can see it's primarily Republican governors that have done this, but there are some Democrats in Delaware and Rhode Island, as well as Virginia has had both parties launch efforts since 2010. You see geographic diversity, also all across the country, primarily Midwest, but every corner of the country has had an effort since 2010. It's also interesting when you just look at the political dynamics. I was a political science major. You have people like Scott Walker and Chris Christie that were preparing to run for president that did this, but you also had Republican governors in what you might call blue states, like Governor Rauner in Illinois, Governor Snyder up in Michigan, Governor Baker and Hogan in Massachusetts and Maryland. So it wasn't this typical partisan issue where this is red meat for the base type of thing you see with some issues. It was a very interesting mix and a very diverse mix of states and governors that got involved. What we saw with these efforts were some common themes that came through when states were doing regulatory reform. There was usually an executive order that launched this program, and this was, I think it's been true for all the 20 states you see on here. It kicks off an effort over a defined time period to go look at all the rules in the state. There's usually a public comment collection period where the state opens its doors and says, tell us what you would like changed. And then at the end, there's some sort of action to respond to those comments through rule repeal or revision, followed by a report in most states to say, here's what we did, here are all the great successes we experienced. When we looked at those models here in Missouri, we started with an executive order that the former governor signed on his second day in office, and it really addressed three different aspects. I like to think of it past, present, and future rulemaking. It dealt with the rules that were already in the pipeline, the present, the rules that were already in the books, the past, and then the rules that would be coming in the future. So just taking those quickly, just to set the framework for what the executive order covered. For the rules that were already in the pipeline, in Missouri, the Administrative Procedures Act, it takes about 6 to 9 months for a rule to go from start to finish. So there was an effort to review what had happened in the 6 to 9 months before the new governor had taken office, and to give us time to get up to speed on those. There was an effort to make sure that going forward, the governor's office could be more involved in rules so that agencies weren't regulating without going through the governor's office. And that way we could have a tighter control going forward to ensure that the reforms this order was going to implement would have a better chance of sticking. And then on the rules that were already on the books, it required the regulations to be evaluated against 6 different criteria. I'll show those here in just a second. There was that public comment period we talked about. Each agency also had to do a report and then complete action over about a 1.5-year time period. The 6 criteria I mentioned are listed here. I won't read them all to you, but the idea for each one of these criteria was to look at the rules on the books each in a different way. So you see there's a cost-benefit analysis on number 2. Number 3, we had a question this morning about how do you know if the rule's working? We wanted people to look at it and say, do we have a process to go back and make sure this rule is working? Number 5 is we wanted to make sure every rule was based on really good science or economic data, whatever it was appropriate for that rule. And then broadly, on numbers 1 and 6, we wanted to make sure that this was a rule we actually needed, that it was actually important to the people in Missouri. To accomplish this review, we assembled a team. We called them the red tape cutters. So each department designated a person to lead that department's review on an effort that would look at every regulation that that department was responsible for. That person was also responsible for going out and gathering the public comments on that department's rules, and then leading the effort to make the changes that were necessary. So we gave our red tape cutters 3 goals. Over the summer of 2017, James came out to meet with us at one of our first meetings, and Professor Lambert came out in the fall, and we encouraged people to read the books. We had a really good support from these experts that we've heard from today to help our people start thinking about regulations in a new way. So we gave them 3 goals. We said, first, the executive order gave you a 1.5 years. We really want you to complete your review by the end of 2017 so that you don't have legislative session in Missouri that's going on, so that you can really focus on these rules and give them the attention they deserve. The second goal we gave them is we said, we looked at all the other states, and on their public comments, they average about 500 comments a state. Massachusetts had the most. They had 1,000 comments. We said we'd like to beat that. We have 16 agencies in Missouri. We want everybody to collect 100 comments per agency. And so that'll give us a 50% increase in above the highest number of comments any state's received. Now the reason for that, it wasn't just to have a goal to shoot for. It wasn't just to set a record. It was what we had seen in other states when we looked at the reports there was a very passive approach to trying to reform and revise the regulations. There was a website set up, but there was no attempt to promote the website. They just kind of sat back and said, well, we're doing a regulatory review, and there was a press release that went out when it started. Hopefully people figure that out. And so we wanted to give people a goal so that the only way they could meet it was to go out and be proactive. You'd have to send emails to your stakeholders. You'd have to go to their meetings. You'd have to really beat the bushes to try to get the number of comments. And then the third goal we gave people was we said, okay, working out that British Columbia model that James talked about and the reasoning and successes behind it, we want everybody to try to cut 1/3 of their restrictions for each department. We don't know if we'll get there, but that's going to be the common goal everybody shoots for. So when you look at where we've come, I just mentioned the public comments. Again, average of 500, we're shooting for 100 per agency. By the end of the process, we'd hit almost 6,000 comments. So we're really proud of that. We had a great team, and I should just make clear that everything that's happened here is not because of me. It was because of the people in the agencies, the red tape cutters, the teams they worked with. They were the ones who were going out doing the work and making this happen. But they did great work. We got a lot of comments. We had a lot of meetings with stakeholders. In fact, there's one agency that was meeting with stakeholders to talk about their rules. And finally, the stakeholder said, you guys are meeting with us too much. We're crying uncle, no more meetings. We're tired of telling you how to improve the rules. That's a really good problem to have when you're you're listening too much and you're wanting input too much. When you look at the timeline. I mentioned we wanted it done by the end of the year. Everybody met that timeline as far as an initial review is concerned, and then that gave us time to start working through the process to actually do revisions and repeals. To date, we've eliminated 19,000 of those 113,000 restrictions. Here's the breakdown by agency. These are all state agency acronyms because that's the easiest way to put them on the chart. But I'd just like to point out the Department of Natural Resources, you may have noticed on James's chart, we're the #1 entity in Missouri. They had 24,000. They cut almost 9,000 of those restrictions. They did an outstanding job. To put these numbers in context, the blue lines show the percentage cut by agency. So even though Department of Transportation only cut 1,500 of their restrictions, that was more than half of the ones they had on the book. So that's an incredible outcome. Department of Revenue, their former general counsel, Ryan Asbridge, is here. They cut 20%. They did a great work at that department. So you can see that across the board, we had really good results. There were some agencies that did better than others, but by and large, overall, this was 19% of the restrictions that were underneath the governor's control. If the people who are doing the math in their heads know that 19,000 is not 19% of 113,000, but that's because some of those are with independent agencies that the governor doesn't control and we could not force to meet our 1/3 requirement. So even though we came up just a little short of our 1/3 goal, almost 20% cut takes us back to the early 2000s on that chart we started with on the number of restrictions. So as far as we know, that will be one of the biggest decreases in a restriction reduction of anywhere in the country. And we're really excited about that. Let me just real quickly give you a few specific examples beyond these numerical data. We had our people generally looking for 5 different things as they went through and tried to repeal and revise the regulations. The first is the regulations that just were not good law. Those were the low-hanging fruit and obvious. There was one of the Department of Agriculture, it created an award program. The legislature repealed it in 2012. We still had a regulation on the books. Obviously, that's not doing anything because there's no enforcement, but there's a potential decision cost because somebody might read that, they might start looking into it. As long as it sits on the books, somebody might start worrying about it. The second one we looked at were just duplicative regulations. These are also pretty low-hanging fruit because there is a temptation among at least state regulators to just copy and paste regulations take the statute, copy and paste it into regulation, which the argument that we received was, well, it's so easy. It's all in one place. You don't have to go look at the statute. Well, a couple problems with that. One, it makes the code really long. 2, the copy and paste was not always completely copy and pasted. So there was a regulation I reviewed where there were 2 sentences that were different from the statute, and it made a material difference on a tax credit, who was eligible and when they could redeem it. Obviously, the statute would control, but all of a sudden, that was a significant problem. And if you're a lawyer in private practice, like I was for years in Kansas City, you had to look and line those up and make sure everything matched. So we said, look, guys, it's easier for folks if you just cite by reference. It's not copy and paste. 3 more substantive areas. We had regulations that were unclear. Department of Natural Resources had a lot of air and water regulations that were, frankly, hard to get through. They really worked to make it more readable, more understandable to someone. We had regulations that were unused. Department of Public Safety had a license for alcohol salespeople. They regulated the wholesaler, they regulated the retailer, but for whatever reason, they were licensing salespeople. And they said, you know, we're just processing these forms, we're doing nothing with them. So they eliminated that regulation because it was really doing no good for either end of the transaction. And then the last category were the ones that of most interest to the folks here were those that were overly restrictive and burdensome on folks. 3 examples, real quick. The first came from the Department of Revenue. Some of you may have read about this one, but there was a requirement on the books that if you were a car dealer in Missouri, you had to have a landline phone. This was put in place in the 1980s, presumably to make sure that you didn't have these pop-up car dealers, I guess, somewhere on the street corner. But in the 30 years that had passed, technology had changed. So we had these car dealers that were writing in saying, you know, the only reason I have a landline phone is because of this regulation that requires me to. I do all my work through a cell phone. So we were able to repeal that requirement because it was no longer necessary by technology. A second one is similar, a technology advancement. The Department of Agriculture had a rule that required milk haulers who have to go through a state-mandated training. They had to do the training in person. And this is a training that we could do online. So we repealed the requirement that you have to attend in person, and that way we could start offering that through the internet. A final one came from the Department of Economic Development. So there was a specific grant that to be eligible for, you had to present an offer from a different state, a financial incentive offer. So we were forcing people to go get recruited by other states and make ourselves the second bidder and potentially lose companies who might get a better deal somewhere else that we couldn't match, or they fall in love somewhere else. It made no sense why we would tell people, before we will give you this incentive, you have to go look elsewhere. And hopefully you'll stay here once we match whatever offer you've ginned up. So we're able to, that's in the process of being repealed. I think it's almost final now. Those were some of the obvious things that we were able to go through. Obviously, there are a lot more examples if you were to go through these 19,000 restriction eliminations of things that we're able to change that I think long-term will have a positive difference here in Missouri. And like I said, it's because of a great team that spanned multiple administrations that we're able to do this. So with that, I think that's all I have. Thanks, everybody.
We have gone overtime, and it was well worth it. You were fantastic. Notice I don't need a microphone. And so I know that in the morning we had the speakers discuss each other's work, and I think in the interest of time, you're all going to dinner tonight, and so you can do that there. I would like to give the audience an opportunity to ask 2 questions, and then we'll let everybody go because it's a Friday afternoon. Questions? Yes?
So, for the 2 gentlemen who just spoke about cutting the red tape, I just kind of have a question as to numbers or statistics, right? So you mentioned other states and countries who have done this, right? Getting rid of old rules that are on the books that clutter up the system and more or less at the end of the day quite possibly affect economic growth. What do the statistics show for those states or countries that have done it before? Has cutting the red tape effectively increased the growth rate? By how much? And what are the criteria that they use to judge that by?
So I know if you looked at British Columbia's GDP per capita growth, for example, in the 80s and 90s, they were the slowest growing province in all of Canada. And then since 2002, they're the fastest growing, except maybe for one very small province, I think. So they've experienced an economic turnaround in the meantime. Can all of that be attributed to red tape reduction? It's hard to say. It's hard to kind of measure the causal effect, these kinds of things. We actually have some research about this in process. But it shows that they were able to cut regulation levels significantly. It corresponded with an economic turnaround. There were also some other policy changes like tax reform that happened in the early 2000s. And they did it without sacrificing public health or safety or the environment. So they're known as one of the most pristine and beautiful parts of Canada and North America. They have one of the longest life expectancies in the world. So it shows that streamlining the code doesn't necessarily sacrifice those things. It may even improve safety and health outcomes and environmental outcomes by just making it easier to comply. Did you want to add something?
No, I think I would agree with all that. British Columbia is the best example, and you asked for which statistic is just a GDP measurement. Right, for that province.
Yeah, I know that the paper industry in particular saw a big, pretty substantial improvements, and they were one of the industries that probably had some of the most regulation removed.
Thanks, Elizabeth, for that question. Yes, good.
This is for Ms. Dooley and Mr. Davis, and I'm just speaking on my own behalf here. But both of you
study, if you will, or focused any of my research on state situations or state constitutions. So in that sense, I was making just federal comments. I mean, that said, I mean, the principles that I talked about that are institutionalized in the federal Constitution as it was written certainly apply, I think, to state constitutions. That is, the consolidation of power or the enactment of legally binding mandates by administrative or what are administrative executive officials instead of the elected politically accountable representatives. I mean, the issues can be the same at the state level.
Professor Dillon, anything to add there? Yep. So I would like to ask the speakers if you would be willing to stay up here just a little longer. I'm going to let people go with, first of all, the thanks to all the speakers and a huge round of applause for the seminal book written by Professor Lambert. Thank you. And then if all of you or any of you have questions of our speakers, because we had to cut the questions short, they're happy to answer your questions. Thanks.
Great job.
Thank you.
Are you still doing this work now?
Tangents